Good morning to all of you. అందరికీ శుభోదయం. Welcome to Legal Matters by Sai Baba Sunkar. Honorable Supreme Court of India, nowadays, they are leaning towards the cancellation of bails granted by the High Courts also. Of course, reasons are there. Another such incident has come to light, where Supreme Court held that not only the Supreme Court, if anybody violates the conditions imposed by the court, the trial court also can cancel the bail. This was stated by the Supreme Court while cancelling the bail granted to a former minister, an MLA, Congress MLA of Karnataka state, Vijay Rajasekhatappa Kulkarni. Normally we call him as Vijay Kulkarni. Why they cancelled? The situation has come to cancel the bail. This is very, very important. We are going to discuss it. The case came before two judges bench of Honorable Justice Sanjay Karol and Satish Chandra Sharma. The name of the case law is the Karnataka, the state of Karnataka, through the Central Bureau of Investigation versus Vijay Rajasekhatappa Kulkarni. SLP number 1865 by 2025. Decided on 6/6/2025, wherein the Honorable Supreme Court of India cancelled the bail granted to Congress MLA and former Minister Vijay Kulkarni, granted by Supreme Court itself. Right. Why he has to take bail is relating to a murder case which happened in the year 2016. 2016 murder of a BJP worker. On 15/6/2016, the BJP worker or district president Yogesh Gowda, he was hacked to death at his gym in Dharwad district after throwing chili powder on his face. It has created commotion. You know, always there was a tough fight between the BJP and Congress party in Karnataka state. Therefore, the issue was entrusted to the CBI, Central Bureau of Investigation, for investigation. The motive for the offence was established as Vijay Kulkarni was already a grown-up leader, and with the auspice of the BJP, Mr. Yogeshwar Gowda, he wants to come up. He is coming as an obstruction. He is growing up as a leader in Dharwad area. So Kulkarni did not want Yogesh to grow as a leader in Dharwad area. Therefore, he has entrusted the work to hired killers or contract killers or hired assassins to eliminate him. As a pre-planned thing, they have come on 15/6/2016 to his gym, sprinkled chili powder on his face and attacked him and killed him to death. In this case, certain persons have been arrested and the conspirator is established to be Vijay Kulkarni, the MLA. Right? So, he was not granted bail up to the High Court level. He approached the Supreme Court. Supreme Court, I think in the year 2011, 11/8/2011, Supreme Court has ordered the bail to be given to Vijay Kulkarni with certain conditions. You know, while reading section 437 of the CRPC or 439 of the CRPC, that is anticipatory bail and bail while in jail, the court can impose strict conditions like, number one, the accused should cooperate with the investigation. It's very funny, but anyway, normally no accused will try to cooperate with the investigation. Accused should cooperate with the investigation, and accused should be available as and when the police calls him, or accused should come and attend before so and so police station on every Friday or something like that. Now we are coming to a very important point. He should not try to meddle with the investigation. He should not try to influence the witnesses. He should not try to make any compromise deals with the witnesses. This is very, very important. Here they failed. Kulkarni through another accused person, Chandu Manna. This Chandu Manna was proved to have approached the victims and tried to actually manage the victim to resign from the prosecution, that too in a statement given under 164 CRPC. ఇది వీడి మీద అలిగేషన్. ఆల్రెడీ ప్రాసిక్యూషను జడ్జి గారి దగ్గర 164లో చేయించారు. ఎస్, దీస్ పీపుల్ హ్యావ్ డన్ ఇన్. కానీ దిస్ మ్యాన్ హ్యాస్ ఇన్ఫ్లుయెన్స్ హిమ్ టు సచ్ అన్ ఎక్స్టెంట్, మేబీ డబ్బులు ఇచ్చాడో భయపెట్టాడో తెలియదు, కానీ దట్ హీ టర్న్ హాస్టైల్ ఈవెన్ ఆఫ్టర్ గివింగ్ 164 CRPC స్టేట్మెంట్. సో ఇది ప్రూవ్ అయింది. దేర్ ఫోర్ ద CBI ఫైల్డ్ ఏ cancellation of bail petition on 25/4/2024. The trial court dismissed, cancelled the bail, but at the same time they could not cancel the bail given to Kulkarni. Endukaya reason ante this bail was granted by the Supreme Court. Go to the Supreme Court and get it cancelled ani oka salaha icharu lower court. So therefore CBI approached on behalf of Karnataka state, approached the Honorable Supreme Court of India. Right? So the petition filed by the CBI, it clearly says that this Kulkarni and another, they tried to contact and influence PWs like Nagappa Bairegaunde to depose against the prosecution, as a result of which, yes, on 15/11/2024, he resigned from the prosecution or retracted from his earlier version, even though his statement was recorded by magistrate under section 164 CRPC. Supreme Court కి అర్థమైంది. Matter is under trial. So therefore Supreme Court said, we don't want to make detailed observations as the trial is going on. It may have effect on the trial. So, be that as it may, there is sufficient material to suggest that attempts are made by Kulkarni. They made their efforts to influence the witnesses. So therefore, the bail granted to Kulkarni is hereby cancelled. Unto the trial court can cancel the bail even though it is given by the Supreme Court if the conditions are violated. Very, very important. If the conditions are violated, definitely even the trial court can take action. Trial court can cancel bail under section 483, clause 3 of the present Bharatiya Nagarika Suraksha Sanhita. Kabatti, don't be under the wrong impression that bail was granted by the Supreme Court. If you want to get it cancelled, so approach the same court అని చిన్న కోర్టులు భయపడాల్సిన పనేమి లేదు. Even though we grant the bail, if the accuser flouts, if the accuser violates the conditions, definitely the trial court is also competent. Trial court is at liberty to cancel the bail. Very, very good judgment by, landmark judgment by Supreme Court of India. Please read it and enrich your legal knowledge. Thank you.